We get this question all the time. Do I need to put an ignition interlock in all my vehicles if I get convicted of a DUI over 0.15 in Florida? The answer is, fortunately, no. I'm Bill Umansky, the lawman. Doing DUI for about 30 years, we get tons of questions, and one of the most common questions is if someone is going to get convicted of a DUI over 0.15, or maybe they do a diversion program, do they have to put an ignition interlock in all of their family vehicles? You see, a lot of people, they get in trouble, they get arrested, and they don't want to burden their family members, their spouse, their significant other, and they don't want to cause a problem for their children or anyone else in the family. So they can deal with the ignition interlock in their vehicle, but they don't want it in the family's vehicle. Fortunately, the answer is you get to choose the vehicle you want the ignition interlock in. Just be careful though, that if you put it in your vehicle and not your spouse's vehicle, for example, you can't drive your spouse's vehicle while you're on probation or in the diversion. You basically cannot drive a vehicle that does not have an ignition interlock in it. So the good news is that you can just put it in one vehicle and not burden your spouse or significant other or children. The bad news is if you get caught driving that vehicle without using the ignition interlock, you could go to jail. I'm Bill Umansky, the lawman, out.